All right, why don't we go ahead and get started? Good morning, everybody. My name is Mike Rampe. I am the General Counsel here at the Broadband Association. And if you are here to learn about the Corporate Transparency Act, then you have come to the right place. So I will go ahead and get started. Before I do so, I'm going to go ahead and go off video. Okay. All right. Again, good morning, everybody. Thank you very much for joining us today for this 20-minute webinar on the Corporate Transparency Act. It's great to have you all. Our goal today is to basically get you up to speed on the basics of the Corporate Transparency Act. And before I get started, I just kind of wanted to give a word of caution. I've tried to be as thorough as I reasonably can within the short amount of time we have this morning. As a practical matter, it would not really be possible to discuss the CTA and how it would apply to every company and every corporate structure. So the Act and its implementing regulations are kind of technical. So unlike other legal and regulatory requirements I might give a webinar on, this one kind of has a limit as to how detailed I can get. So if you have a question after today, I suggest consulting your company's legal counsel, and that can certainly include me here at the association. And I'll also be telling you about some additional resources. So today's objective is to give you an overview and to kind of get you thinking and to get you started on the compliance with the Act. Okay, so let's jump in. First things first. Let's talk about the purpose of the Act briefly. The federal government has become concerned and I guess frustrated in recent years by the fact that when it's tried to investigate companies for potential illegal activity, it's had difficulty. It's run into difficulty because often it can't, in the course of doing its investigation, it can't tell who the companies are owned by. And this because in many cases, corporate structures are very complex and it's difficult for the government to tell which companies own which and who their ultimate owners are. So the Act is here to require companies to make certain disclosures about their ownership, which it furthers Congress' goal to help prevent financial crimes. And we're mainly talking about things like money laundering, tax evasion, things that are crimes that are committed through shell corporations. Okay, brief legal history. The Corporate Transparency Act, which I sometimes will refer to as the CTA or maybe just the Act, was enacted on January 1st of 2021. So, and the requirements I'll be discussing today did not go into effect immediately. Instead, the Act required the Secretary of Treasury to promulgate regulations to implement the Act's reporting requirements not later than 1 year after the Act's enactment date. And those regs were eventually published in September of 2022 and became effective January 1st of 2024. So that's why we now need to discuss the Act, because the reporting requirements are now in effect. So what does the CTA do? Generally, what the Act does is it requires companies to file information with an entity known as FinCEN about the individuals who ultimately own or control those companies. And to be clear, when I say FinCEN, I'm referring to the U.S. Treasury's Financial Crimes Enforcement Network, which is abbreviated FinCEN. I should point out that FinCEN has its own website for companies to use. So when companies who have to make their filing, they do it through the FinCEN portal on its website. That website's pretty good. It has an FAQ page. It has a compliance guide on there. So it's got a lot of resources, but more on that later. Let's dive into who has to make these filings I'm referring to. Okay, so under the CTA and its regulations, a reporting company must file information about its owners with FinCEN. The act requires, or I should say, it recognizes basically two types of reporting companies, which I have listed there. Those are domestic reporting companies and foreign reporting companies. We'll just focus on domestic reporting companies this morning, because I think that's really the focus of the folks on the call. So let's talk a little bit more about what a reporting company is. The definition of reporting company is laid out here. It's basically a corporation or an LLC or similar entity that was either created through the filing or a filing with the Secretary of State or a similar state office under the law of a state or an Indian tribe. Or it could also be, as I mentioned earlier, a company that was formed under a foreign company's law and registered to do business in the U.S. By the filing of a document with the Secretary of State or similar office or a tribe, or under the laws of a state or a tribe. And importantly, it does not fall within an exception. So, again, focusing today on domestic companies. If your company was formed by the filing of a document with your state's Secretary of State office or a similar office, then you are a reporting company unless your company falls within an exception. I would note that Michigan corporations, we file with the Department of Licensing and Regulatory Affairs to start when we form companies. So that's not the Secretary of State, but that's a similar office. So that's going to count. Okay. As I mentioned, the CTA has many exceptions from the reporting company definition. There are a total of 23. And I've summarized them here on this slide. It's not a complete list, but I want to just at least to give you a kind of a general summary or a general flavor of the types of entities that are exempt. Of course, I have to back to my caveat earlier. Any entity that thinks it might fall within one of these exemptions would want to review the rules very carefully and consult legal counsel. And as I pointed out, the FinCEN website also has materials that can help companies determine whether they might fall within one of these exemptions. And I do want to call out a few of these. The first one you see in the upper left corner there, securities reporting issuers. This is basically referring to an entity that's an issuer of a class of securities that are registered pursuant to Section 12 of the Securities Exchange Act of 1934. So like at a high level, we're talking about companies that have gone through the process to have their stock or other securities traded publicly. It also refers to entities that were required to file are required rather to file supplementary or periodic information under Section 15D of the Securities Exchange Act of 1934. Again, these are, this relates to companies that have, securities that are publicly exchanged in some way. Obviously, that could get very complicated. That's beyond the scope of what we covered this morning on this webinar. But so if you think your company might fall under that category, I encourage you to check with your corporate counsel. Like I said, I really couldn't get into it too deeply this morning, but I wanted to call your attention to that exemption. Okay. You probably saw the previous slide. There is an exception under the Act for of reporting companies for public utilities. The Act excludes, and this is the language of the Act. It says it excludes, quote, a public utility that provides telecommunication services, as well as electric power, natural gas, those water, sewer, those kinds of things that you'd expect. The Act does not, however, define the term telecommunication services. That's kind of laid out in the implementing regulations, and unfortunately, if you pick through the regulations, it kind of amounts to basically you have to be a provider of telecommunication services that are rate regulated by a state commission or the FCC to qualify for that exemption. So what might at first have appeared to be language that would allow telecommunications providers to avoid having to report, unfortunately, it doesn't appear to help us here. In Michigan, at least, telecommunication services are not rate regulated, nor can they really be said to be rate regulated at the FCC. So I wanted to let you know we did take a close look at this one, but ultimately it's not going to help us. Okay. There's also a large operating company exception. I want to call attention to this one because some BAM members may meet this exemption. Under the Act, a reporting company does not include a large operating company, and I've got the definition here. We're talking about large companies that employ more than 20 employees on a full-time basis, and they must have filed a U.S. federal income tax in the prior year demonstrating more than $5 million of gross receipts or sales in the aggregate, which includes a couple items there listed in the bullet points. And it has to have an operating presence at a physical office within the U.S. So some member companies may qualify for this exemption. The regulations on this exemptions are technical. So there's very technical definitions on what you get to count in terms of your employee head count, what counts as gross receipts or sales, what it means to have an operating presence, and so forth. So any entity that thinks it might meet this exemption should consult further to make sure that it meets all the requirements. Okay. There's also a subsidiary exemption I wanted to call out. And before, I guess this would be as good a time as any to maybe so recognize that companies have to report on themselves and they have to report potentially on their subsidiaries. The way the Act is structured, basically all entities have to report. So you might be thinking to yourself, well, if my parent company reports, can I just file a single report on behalf of all of our companies? And unfortunately, the answer is no. Any company that meets the definition of a reporting company and is not exempt is going to have to file its own report. Now, so let's jump into the subsidiary exemption. Basically, what this says is that if any entity meets the definition of a reporting company, but it is wholly owned or controlled directly or indirectly by an entity that is exempt, then the subsidiary is not a reporting company, unless its parent company is one of the types I have listed here. So basically it's an exception, but then there are exceptions to the exception. So this is, a little tricky. So if the parent company is exempt, then the subsidiary might be. It can't be one of those kinds of companies I have listed there. So we're talking money transiting businesses, pooled investment vehicles, entities that assist tax-exempt entities, inactive companies, things like that. There is also, as I underlined there, the qualifier that it's got to be a wholly owned or controlled subsidiary. So I recognize this is a lot. I don't expect anybody to memorize this exception or these definitions, but I wanted you to know this exception exists. And I would recommend, if you think this might apply to you, if you think that you're a subsidiary of an exempt parent, then you'd want to look through the material. I think the place to start would be to go through the FinCEN website, look at the FAQs, look at the small entity compliance guide, or call your legal counsel, including me. Okay. So, I've been talking about who's exempt, who's not exempt, who's a reporting company, who's not. But I haven't really talked about what, what you would have to file if you were a reporting company and were not exempt. So let's set aside the exemption issue for a second and just talk about what a reporting company that doesn't have an exemption would have to file. A reporting company has to report information about itself and two categories of individuals, those being its beneficial owners and its company applicants. And I'll cover those two categories in the next two slides. So what's a beneficial owner? A beneficial owner is an individual who directly or indirectly, through any contract, arrangement, understanding, relationship, or otherwise, exercises substantial control over the entity or owns or controls not less than 25% of the entity. I will get into I guess I'll get into the substantial control aspect in a minute, but regarding the 25% ownership requirement, I mean, that's a mathematical thing, so that's more straightforward to apply. I would point out another wrinkle here. This applies to directly owned and indirectly owned entities. Okay, so if, for example, I were a 50% owner of company A, and company A in turn owned 50% of company B, then I'm going to be a beneficial owner of, I'm going to be a 50% owner of company A, okay? But then I'm also going to be a 25% owner of company B. So I'm going to be considered to be a beneficial owner of both. And so think about that a little bit. And just to add another potentially confusing wrinkle, under this, under similar circumstances, again, if I were to own 50% of company A, and company A owned 25% of company B, then I'd be deemed to be a 50% owner of company A, but only a 12.5% owner of company B, and would not be considered to be a beneficial owner of B. If you did not capture all of that, don't worry. Again, this is laid out pretty nicely in the compliance guide that's available on the FinCEN website. They've got a lot of different scenarios that are laid out there. So I just kind of wanted to preview that. And again, happy to talk through it with any member companies. Okay, let's talk about what it means to have substantial control. Substantial control. You'll recall this is the second way that a person could be considered to be a beneficial owner. The first being if you're a 25% owner. So back here on this slide, these are the information you have to report information about beneficial owners and company applicants. We covered the 25% ownership requirement. So now we're going to talk about the substantial control requirement. Okay, the statute does not define substantial control, but it does come from the regulations. And I've listed out kind of the main ingredients for what it means to be a person who has substantial control over an entity, such that they would have to be reported on the as a beneficial owner. So we're talking about an individual who is a senior officer, somebody like a president, a CEO, a CFO, general counsel, COO. We're talking about somebody who has authority to appoint or remove officers or directors. We're talking about somebody who can make important decisions about the company regarding its nature, its scope, its attributes. Somebody who would have authority to, direct reorganization, dissolution, or mergers of the company, or can approve major expenditures or investments. Again, I want to give you the flavor. The compliance guide gives a lot more examples and gives an in-depth analysis. So I would refer folks there for a little bit more guidance on that. And again, I'm happy just to discuss it with any member companies who want to. Just briefly here, there are some exceptions to the definition of beneficial owner. when an individual falls within one of these exemptions, then the reporting company does not have to report that individual as a beneficial owner to FinCEN. I've listed them here. There's a lot of information. I won't go into that in detail, but the exemptions basically include such things as minor children. Their parents and guardians would have to report, but the children would not. Those who act solely as agents or custodians on behalf of a corporation or other individuals, persons who act solely as employees but are not senior officers, and some others. Again, the compliance guide fleshes this out pretty well. So do the online FAQs. I do want to make one other note. In cases where an exempt entity has a direct or indirect interest in a reporting company, then the subsidiary reporting company must report, but only the exempt company's name is reported, not the beneficial owner. Okay, so if your company is owned by an exempt entity, then your company, but for some reason your company still meets the definition of reporting company, you would just report the exempt entity instead of the exempt entity's beneficial owners. Now you might be thinking, hey, wait, Mike, you just told me a few slides back that under the subsidiary exemption, if an exempt entity has a subsidiary, then the subsidiary is also exempt. So why would a subsidiary have to report anything? And the answer is, based on the information of that slide, you'll recall that the subsidiary exemption is technical, and that if not all the language is satisfied, then the subsidiary might still meet the definition of reporting company and have to file a report. Okay. Okay. If you have to report information about your beneficial owners, you might be thinking, well, what am I going to have to report? I've listed the items here. Basically, if you have to report information about your beneficial owners, you're going to be providing those folks full legal names, their date of birth, their residence or business address, and some kind of unique identifying number from an unexpired document, like from a U.S. passport or from a state driver's license, state ID, those kinds of things. So this is what you will be reporting if you're required to report information about your beneficial owner. Briefly, applicants. I mentioned earlier that a reporting company, in addition to providing information about its beneficial owners, also has to provide information on its applicants. An applicant is nothing more than the individual who directly filed or is primarily responsible for filing the document that created the company in the first place. Not all reporting companies are required to report information on their company applicants. A reporting company does have to report on its applicants if it is either a domestic company that was created after January 1st of this year, or if it was a foreign company that was registered to do business after January 1st of this year. So if your company is a domestic company and it was created after January 1st of this year, you are not required to report your applicants. So that's probably most of the companies on this call, which I'm sure is a relief. Many of your companies were created 100 years ago. You wouldn't want to have to track down that information. So if by the way, if a company did have to provide information on its applicants, we're only talking about information on one or at the most two people. You'd be filing information on whoever created the company by filing the document with the state. And if there was a person behind the scenes that directed that person to make that filing, you'd be providing information on that as well. But that's it. And it's the same type of information you'd be filing for your beneficial owners. It's the person's name, address, and so forth. Okay, reporting timelines. So if your company is required to file a report with FinCEN, when must it do so, or when must it do so? Reporting companies that were created or registered to do business before January 1st of this year have to make a filing on or before January 1st of 2025. So that's probably most of the folks on this call. If a company was created or registered after January 1st of this year, but before January next year, you got 90 days to make your filing. And if looking forward, companies that are created or registered on or after January 1st of 2025, they'll have 30 days basically from creation to file their report with FinCEN. Okay. I'll just say generally, because I know we're running long, there is an ongoing duty to correct and update your report. So if there are changes to any required information that was previously provided in a report, then those changes or updates need to be made generally within 30 days. If we later realize we have an inaccuracy in a filed report, it needs to be corrected within 30 days. Companies that maybe at one point were exempt but lose their exemption, they must make a filing within 30 days. There's a lot that's really laid out pretty clearly in the compliance guide. So I think if there's any questions on that, they're pretty easily answered. Okay, and again, briefly, I'll just say that the Act provides for fines and imprisonment potentially for non-compliance, or if the person provides false information to FinCEN. I think that's pretty straightforward. There are questions, I'm happy to talk that through, but hopefully that doesn't come up. And then finally, I did want to tell you about a couple of federal lawsuits that are recent developments. A couple of weeks ago, on March 1st, the federal district court, a federal district court in Alabama ruled that the CTA was unconstitutional. They basically concluded that Congress exceeded its power as set forth in the U.S. Constitution. The court issued an injunction against the enforcement of the CTA, but only for the benefit of the individual plaintiffs in the case. So only the parties that were in that case can take advantage of that ruling. The Justice Department has already notified the parties that it's going to appeal. In fact, it filed this notice of appeal on March 11th. So we'll see how that one turns out. Because the Alabama federal court did not issue anything like a nationwide injunction, which that would be very rare, basically the act remains in effect for everybody except for the parties in that case. So I want to note that the Small Business Association of Michigan filed its own lawsuit in a federal court in Grand Rapids back on March 26th or thereabouts. I think some other states have seen similar filings, so we'll have to keep an eye on those things. But basically, at this point, if your company, you know, we'll have to see how things turn out. But right now, the act is in effect. So if your company was created before January 1st of this year, then basically you've got until January 1st of 2025 to make your CTA filing. So if you want to kind of wait and see if any federal court rulings come out this year that will excuse you from having to file, you have some time. But if no relief comes by the end of this year, you'd be out of compliance if you didn't make your filing by January 1st. So all I can say on those federal cases is stay tuned. We'll let you know if something occurs that, you know, might affect your obligation to file. This is possible. I think we all know courts move slowly, and even if the Grand Rapids court were to somehow, if the federal court in Grand Rapids were to issue a ruling similar to the one that the Alabama court ruled, we would expect, and I wouldn't expect it to apply beyond the litigants in that case, the named plaintiffs, and I would expect the government to appeal to the Sixth Circuit Court of Appeals. That's going to be a timely process. I don't know if the Sixth Circuit would come out with a more widely applicable ruling prior to the end of the year. So at this point, companies should plan to make their filings by the end of the year. Okay. I know that was a lot of information. I know that we've run over. I did want to kind of give you all that information. Again, I know I throw a lot at your way this morning. I've got the information on the FinCEN website posted. There's a lot of very good information there. I'm happy to talk through issues with any company. Every company is different. Every company has its own different holding structure. And so I'm happy to have offline discussions with anybody so desiring. I assume we have some questions in the chat. Okay, somebody asked about exemption options. I think we covered that. If there are any questions about those, please give me a call or an email. I'm happy to go through those. Another question. Okay, Scott notes that today's presentation has been recorded. It will be posted on the members only section of the BAM website, so it can be reviewed as needed. Thanks for the blessings, Luke. Does anybody have any general questions that I can try to answer here with the time we have? I'm happy to hang on for a few more minutes. Okay, well, if there are none, again, I'm here, happy to talk through any of these issues. We've got 8 months roughly, and I look forward to working with the companies and keeping you updated on the status of those federal cases. Have a good one.
Mike, thanks for going through that with us. I appreciate it.
All right, you bet. Thanks.